Good day, everyone. Welcome to this webinar, the fifth in the SCAI webinar series. Today on the subject of the new Swiss arbitration law. the Swiss Arbitration Association, and SCAI, the Swiss Chambers Arbitration Institution, started this webinar series earlier this year. As I mentioned, this is the fifth in the series. This collaboration is aimed at providing insights on key arbitration topics from experienced experts, and today is no different. This webinar will be available on both the ASA and the SCAI websites immediately after this in the form of a video. The presentation will also be made available. And just to mark your calendars, the next episode, the next webinar will take place on the 21st of January, also a Thursday at 1 p.m. The subject will be how to appoint arbitrators and mediators. Our speakers will be Bernd Ehle and Pierre Muller, and another speaker yet to be announced. It will also include a presentation on the revised rules of SCAI as appointing authority and case administrator. We're happy that our host today, our moderator, will be Alexandra Johnson. Alexandra is an experienced practitioner and partner at Baron Carr in Geneva. And since there's a lot to get through, I won't take any more of your time and will hand the floor over to her. Alexandra, the floor is yours.
Thank you very much, Alex, for your introduction. Welcome to all of you, and thank you for taking the time to join us today for this webinar. We're so happy to have had a record number of registration from Switzerland and from abroad. So it's true, we have an exciting topic to discuss today, which is the revision of Switzerland's International Arbitration Statute, namely Chapter 12 of the Swiss Private International Law Act, commonly abbreviated PILA. So you certainly already know that the revision of Chapter 12 was adopted by the Swiss Parliament last June, and will enter into force in only just about 3 weeks from now, on 1st of January 2021. A rare occurrence, because it's the first time that the Swiss International Arbitration Statute undergoes a revision since its entry into force nearly 30 years ago in 1989. But as you will hear today, the idea was not to tear down the Act and make a new one from scratch, because the Act was recognized by all petitioners in Switzerland and abroad to be a successful piece of legislation that was modern, that was clear, that was concise, that provided the parties with great autonomy, yet at the same time provided them also with some fundamental guarantees and a legal framework to enforce them. So rather, the goal of the revision was to preserve these characteristics of Chapter 12 that made the Act so successful thus far, and to only make those amendments which were necessary to further modernize and improve the Act. So it was only as much as necessary, but as little as possible, as the Swiss motto goes, which also applied to this revision. And so to address our topic today, I have the great pleasure to introduce Professor Daniel Girsberger and Dr. Philipp Habegger, who have both been closely involved in the revision project. Indeed, Professor Girsberger was part of the expert working group which advised the Swiss Federal Council and the Department of Justice in drafting the new legislation. And for those who do not yet know him, Daniel Girsberger is a tenured professor at the University of Lucerne, where he teaches Swiss and international private law, business and procedural law, as well as comparative law. He's also a head lecturer and a member of the Advisory Council of the Swiss Arbitration Academy. In addition to his academic work, Daniel Girsberger is also an experienced and well-known arbitrator and is of counsel at Wenger and Willi, a major Zurich business law firm. Now, turning to Dr. Philipp Habegger, he's the principal of Habegger Arbitration, which he founded in 2017 after many years as partner in leading Swiss law firms in Zurich. He has acted as counsel and arbitrator in more than 200 arbitration proceedings. And aside from his current arbitrator's practice, he also teaches international arbitration and international sales at the University of Zurich and is a member of the faculty of the Swiss Arbitration Academy. Importantly, Philipp Habegger is also the immediate past president of the Arbitration Court of the Swiss Chambers Arbitration Institution, SCAI, and in this position, he closely followed the revision of the Chapter 12 and made some important suggestions and changes. So as you can hear, we really have today uniquely qualified speakers to present the main amendments brought to Chapter 12. They will tell us what's new and what remains the same, and they will in turn present a selection of the new provisions. They have prepared slides with an unofficial English translation of Chapter 12 showing all the amendments in track changes. These slides are already available in the files folder at the right-hand side of your screen and will be posted on the ASA and SCAI websites. So lastly, please note that the questions will be taken at the end of their presentations, which will last for about 25-30 minutes. However, I really already encourage you to put your questions in the chat box that you can see on the right-hand side, and I'm happy to see is already used by the participants. So put your questions there as we go along so we can turn to them immediately after the presentation. So without any further ado, I now turn to Professor Daniel Girsberger. Thank you.
Thank you so much, Alexandra, for these nice words. Ladies and gentlemen, dear colleagues, it's a pleasure for me to be here to speak to you about this fascinating project, of which I will spare you the long history because it's 12 years long. So that's typical for the Swiss legislator to make things slowly but precisely. The story began in 2008 in March and ended, as Alexandra said, on the 17th of June with the parliamentary decision to enact the revision. Because of the success of Chapter 12 in legal practice, the federal government decided not to completely revise this chapter. Instead, it limited the revision to the following aspects. First of all, codification of case law. In order to improve the user-friendliness of Chapter 12, the Federal Council codified or proposed to codify case law of the Swiss Supreme Court and, where deemed necessary, rectified it, as I will show in short using one example. Secondly, it was about clarification of controversial issues. The original Chapter 12 left various questions unanswered, and the Federal Council decided to use the opportunity to clarify some of these issues. For example, it codified the rules regarding the revision, or as we call it, revocation of an award, of which Philipp will speak later. Third point, strengthening party autonomy. The Federal Council wanted to preserve and further strengthen this principle. That is by adding a provision which ensures that it is possible to start arbitration proceedings if the parties have not agreed on a precise seat, and rules on unilateral arbitration clauses. The first element of which I just spoke you can find in Article 179(2). Arbitration in Switzerland would now suffice, as opposed to what was the situation before, and that was an important change. Next, there have been new provisions added regarding the assistance by Swiss courts to arbitrations having their seat abroad. I will speak of that provision in a minute. And it was also one of the goals to improve user friendliness. Since Chapter 12 is used by many foreign practitioners who are not familiar with Swiss law in general, it was considered important that Chapter 12 is a standalone arbitration act with as few references to other acts as possible. Therefore, the Federal Council replaced various references to provisions in other legal acts with direct rules in Chapter 12. For example, regarding the appointment, challenge, dismissal and removal of an arbitrator. You will find these provisions in Articles 180 and following. There are new provisions there, like Article 180A and B, and they replace the references made to the Swiss Code of Civil Procedure for these matters, which has a more extensive regulation of these issues, but it was considered important to adopt these provisions also in the SPILA itself. And finally, the legislator introduced the right to submit challenges of arbitral awards before the Supreme Court in English. This was the only issue that led to discussions in Parliament, and Philipp will talk about these as well. Let me now turn to some individual new rules. Article 176. You see there are only a few changes here, but they are not unimportant. I will let you read paragraph 1, which says the provisions of this chapter apply to any arbitration if the seat of the arbitral tribunal is in Switzerland and if at the time when the arbitration agreement was entered into, at least one of the parties had neither its domicile and so on in Switzerland. Before the clarification in this paragraph, in 2002, the Swiss Supreme Court found that only the domicile or seat of the actual parties, that is, the parties participating in the arbitration proceedings, was relevant. And it did not take into consideration the domicile, habitual residence, or seat of persons that were party to the arbitration agreement, but not to the arbitration proceedings. As a consequence of this practice, the law governing the arbitration, especially in multi-party agreements, could not be determined until it was clear who the parties to the arbitration proceedings were. This uncertainty was a main reason for strong criticism from legal doctrine, and this criticism led the legislator to rectify the practice of the Supreme Court. Paragraph 1 now makes clear that for the determination of internationality, it is decisive which parties concluded the arbitration agreement, even if they are later replaced. That is, for example, on the basis of a merger or an assignment, until the arbitration proceedings were initiated, and irrespective of whether they have moved their domicile from or to Switzerland in the meantime. Please also note that when opting out from Chapter 12, which is possible still, of course, the opting out must be formally declared. This opting out agreement and any other agreement regarding the arbitration, that is the arbitration agreement or a waiver of the right to challenge the award, must now, and that's new, conform to the formal requirements that I will speak about now regarding the arbitration agreement. Let me thus change the slides, shift the slides to Article 178, which is really the relevant provision on the arbitration agreement. As you see, the arbitration agreement must meet the requirements as to form by the Swiss Lex Arbitri, and that's in Article 178.1. The substantive validity of an arbitration agreement is determined by Article 178.2, which remained unchanged. Let's go back to paragraph 1. Under this paragraph, an arbitration agreement is valid as to form if it is made by a means of communication that is evidenced by a text. Consequently, the arbitration agreement can be contained in letters, written confirmations, notes, minutes, general terms and conditions, emails, texts contained on digital storage devices, etc. All that is required is that the content of the expression of intent reaches the addressee in a visually perceptible and physically reproducible form, allowing the arbitration agreement to be evidenced in writing. This requirement is complied with even without the party's signature. That has been undisputed even before the revision. However, there is still an issue, namely whether it is sufficient if only one party adheres to the formal requirements. That is, whether oral or tacit acceptance by the other party is sufficient. The Swiss Supreme Court has not yet given an express ruling in this regard. Some authors took the view that compliance with the formal requirement of Article 178.1 by only one party is sufficient. Others were of the opinion that the form requirement must be met by all parties to the arbitration agreement and that consequently tacit acceptance by the other party is not sufficient. With its consultation draft, the Federal Council proposed to moderately relax the form requirement by explicitly stating that an arbitration agreement is valid as to its form if only one of the parties meets the former requirement. However, the proposed amendment was rejected by many participants of the consultation procedure, mostly because proof of consent would often be difficult to establish. It was eventually not adopted in the final text. Now, the report of the Federal Council, that's the official commentary of 2018, states that there shall be no further relaxation of the form requirement by requiring only one party to adhere to the form requirement, thus implying that all parties must adhere to the form requirement. Personally, I welcome this conscious decision to allowing tacit consent, to not allowing tacit consent, but I know that some uncitral model law countries would disagree, some of them, such as France, even allowing oral arbitration agreements. But I think because of the difficulties to prove the arbitration agreement and also the mixture of form and substantive requirements, I think that was a right and conscious choice. Now let me hand over to Philipp.
Thank you. Good afternoon, everybody. Pleasure having you all participating in this, and thank you, Alexandra, for the kind introduction. As you see in the heading of Article 178 and paragraph 4, there is some new text. And indeed, one of the novelties of the revised act is that it has now an express provision providing for arbitration clauses in unilateral legal acts. What did the legislator have in mind from a Swiss law perspective? One could consider wills, articles of incorporation of foundations, articles of incorporation of companies or corporations. Then, of course, the promise is binding without acceptance, the Preisausschreiben, Ausloben, or in French, promesse publique, in pursuant to Article 8 of the Swiss Code of Obligations, and not yet in Swiss legislation, but trusts, as we know them from other jurisdictions. Now, you see that the language in paragraph 4 is somewhat cryptic because it says that the provisions of Chapter 12 apply mutatis mutandis to an arbitration clause provided for in a unilateral legal act or included in articles of incorporation. That, of course, is quite vague, and in that sense leads to certain legal uncertainty, but it was a, I think, wise and conscious decision of the legislature not to provide for more detailed, because the scenarios might substantially differ depending in what type of a unilateral legal act the arbitration clause is included. So what is the reference mutatis mutandis? How far does that reference go? In the official message of the government, first, it is stated that that reference is to be looked at for the purposes of distinguishing the scope of application between Chapter 12, i.e. international arbitration on the one hand, and the third part of the Civil Procedure Code, i.e. the domestic arbitration on the other. Now, we know that that distinction in the context of arbitration agreement is made on the basis of Article 176, paragraph 1, which has just been addressed by Daniel. And international arbitration legislation applies if at least one party does not have its domicile or its corporate seat in Switzerland. Now, when we're speaking of unilateral legal act, we only do have one party. So likely the correct way in approaching this is that if the promissor of a unilateral promise, or if the company in which the arbitration clause which provides for articles of incorporation in which the arbitration clause is included is Swiss, that would suggest likely that we then are dealing with the application of the Swiss domestic arbitration legislation, whereas if that one party resides abroad or has its corporate seat abroad, Chapter 12 would apply. We will look at later in the context of Swiss company law whether that also means or still allows for the opting out or opting in and moving between Chapter 12 and the third part of the Swiss Civil Procedure Code or not. The federal government in its message then further says that the reference also applies to the requirement of form, as just discussed by Daniel. I think that's rather easy to check whether that form requirement applies. And it would also apply to the provision in Article 187, paragraph 1, which deals with the applicable law on the merits, i.e. the closest connection text in the absence of a choice of law agreement between the parties. The government message also says that it's decisive for the mandate of the arbitral tribunal, i.e. the receptum arbitri, which, however, is a topic on which the Act actually does not provide any express provisions. I would propose, and that was not mentioned in the government's message, that we should also read the mutatis mutandis application with a reference to Article 194. That is the provision which in the context of enforcement of foreign arbitral awards makes a reference to the New York Convention. Now, as you will know, the New York Convention itself, as regards scope of application, that scope is limited to bi or multilateral arbitral agreement, i.e. it does not apply to arbitration clauses contained in unilateral legal acts. I would suggest that Article 178, paragraph 4 makes clear that in future, Swiss courts seized with a request for recognition or enforcement of foreign arbitral award rendered on the basis of an arbitration clause contained in a unilateral legal act will have to apply the New York Convention by analogy, mutatis mutandis, on the basis of paragraph 4 of 178. Now, likely the most difficult cross-reference or reference is to Article 178, paragraph 2, because here, when it comes to the substantive validity of the arbitration agreement, we have the three alternative options, i.e. Swiss arbitration law says the arbitration agreement is valid if it conforms either to the law chosen by the parties, the law governing the subject matter of the dispute, in particular the law governing main contract, or if it conforms to Swiss law. And I think the crucial question really is to which extent this provision may be applied mutatis mutandis in the context of unilateral legal act. Just to, by way of an example, let's assume there is a company incorporated in country X, and corporate law of that country does not allow for arbitration clauses to be included into the articles of incorporation. How should now the issue be dealt with in the context of Article 178, paragraph 4. Let's assume the articles of incorporation of that company provide for an arbitration clause and a seat in Switzerland. Is then jurisdiction established because Swiss law, Swiss corporate law, as I will explain later, now allows for arbitration clauses in articles of incorporation? Or can company incorporated in country X say, I provide for an arbitration clause in the articles of incorporation, Swiss seat, and I subject that arbitration clause to the law of the Netherlands, because Dutch law allows for arbitration clauses in articles of incorporation? I'm skeptical there. So I think in particular the reference to paragraph 2 of Article 178 has to be read with a lot of caution, and in most instances it will have to be determined in application of the law governing the subject matter of the dispute whether there is a valid arbitration clause for the purposes of an arbitration in Switzerland. I would now like to turn to briefly expand on the topic more specifically in the context of Swiss corporate law. Actually, at the very same day this year, Swiss Parliament also passed the revised Swiss company law, and that revision provides for a new Article 697N in the Swiss Code of Obligations. That piece of legislation will not yet enter into force on January 1st next year. I have not checked yet whether the date of the entry into force has already been determined or not by the Swiss Federal Council, but it will definitely take some more months, if not a year, before that article comes into force. This article now makes clear that the current provisions in the Swiss Code of Obligations, primarily Article 680 of the Swiss Code of Obligations, are no impediment to arbitration clauses in articles of incorporation. The vast majority of scholars held that in principle, corporate disputes are arbitrable under Swiss law, but there was a discussion whether Article 680, paragraph 1 of the Swiss Code of Obligations was an impediment to that. The new provision now makes clear that Article 680, paragraph 1 is no impediment. The new provision also makes clear that arbitration clauses in articles of incorporations are of a corporate nature because they can be introduced with a qualified quorum by virtue of a shareholder resolution, and they are binding as well on those shareholders which voted against that resolution. Similarly, they are binding upon the company itself, the bodies of the company, such as, for instance, the board of directors, including the individual members of the board. However, this said, if arbitration clause is included into the articles of incorporation at the point in time the company is formed, then we actually do not have a unilateral arbitration clause. We do have an arbitration agreement, because in the process of forming the companies, all founders of the companies have to unanimously agree to the articles of incorporation. So in that instance, we actually do have an arbitration agreement. Similarly, it is held by scholars that if someone purchases shares at a later point in time, after the provision in the article of incorporation containing the arbitration clause has come into force, a derivative acquisition of shares leads to an arbitration agreement. Hence, you agree to the arbitration clause in the articles of incorporation, and you're speaking of a consensus. That principle will be reinforced in that it is proposed that the commercial registry will in future show in the publicly available entries for a specific company if that company has it in its articles of incorporation a clause providing for arbitration. So the arbitration clause will be deemed public knowledge. I'm turning now to another subject matter, which is the challenge of arbitrators. I wish to point out first in this context to the new paragraph 6 of Articles 179, which now expressly states continuous duty of an arbitrator to disclose any potential conflict of interest. That duty not only applies when the potential arbitrator is approached by a party, but continues throughout the proceedings. Articles 180 has a few amendments, but they primarily reflect what already is consistent case law of the Swiss Federal Supreme Court. In paragraph 1, letter C, you find that it is now clarified that an arbitrator not only has to be independent, but also impartial. As stated, this is consistent case law of the Swiss Federal Supreme Court, but has now been clarified in the law, in particular, of course, for the benefit of users abroad. Second point, which already is as well consistent case law of the Swiss Federal Supreme Court, is that now reference is not only made about the specific knowledge of a party, knowledge about the ground for challenge, but an objective standard is now expressly stated in the Act, in that the time limit for a challenge starts to run from the point in time a party was or should have known, could and should have known about the ground for challenge in the exercise of reasonable diligence. That first leads to more legal certainty, of course, when any time limit to challenge arbitrator starts to run, but it also is easier to determine that point in time because it's always a difficult exercise in establishing actual knowledge of a party. So an objective test will definitely help to make sure that the risk of dilatory tactics can be reduced. The challenge procedure is a two-tier procedure. Once a party knows or should, in the exercise of reasonable diligence, know about the ground for challenge, it has 30 days to notify the challenge to the challenge member of the tribunal and to all other arbitrators. And if then the issue is not resolved, it has another 30 days since it made the notification of the challenge with the arbitral tribunal. It can apply to the state court. This said, of course, party autonomy prevails. So in institutional arbitration, it's the institutional frameworks of the ICC of SCAI which applies. The provision in Article 180A is really applicable pursuant to its wording in the instance of ad hoc proceedings. I'm now moving on to the new provision on revision and or revocation, to which Daniel alluded to a minute ago, and that's the new Article 190A of Chapter 12. I will only discuss in that context its paragraph 1, letter C, which deals with a challenge of an award if the ground for challenge of an arbitrator was only discovered despite the exercise of due diligence after the final award in the arbitration was rendered. That issue was not addressed in the current law. The Supreme Court left the issue open in its decision 142 Roman 3 521. The provision really aims at safeguarding the constitutional and the requirements of the European Convention on Human Rights, Article 6, paragraph 1, number 1. What is important in this context is that the grounds for challenge are narrower here in revocation proceedings than they are in setting aside proceedings. In setting aside proceedings under Article 190, paragraph 2, letter A, you can also challenge an award for improper constitution of the arbitral tribunal if a member of the arbitral tribunal did not meet the agreed qualifications as agreed by the parties. That ground for challenge, or that is not available in revocation proceedings, as is made clear by virtue of the reference to Article 180, paragraph 1, letter C, in letter C here in the revocation provision. This is a change which was introduced by Parliament only, but an important change because, of course, it's necessary in order to safeguard the finality awards that the grounds for revocations are truly limited to those grounds which are of a constitutional or human rights convention level and not to mere party agreements. That's what I wanted to say in this context, and I'm now handing back to Daniel.
Thank you very much, Philipp. I'm going back 5 articles to elaborate a little bit on the new provision, Article 185A. This article was added, and it's not something strange because many arbitration laws establish a right to apply to state courts for coercive measures. For example, with regard to interim measures, the taking of evidence or other general assistance issues. However, some of them do so only for arbitrations seated in the country of the state court where the request is made. This was also the case with regard to our law before the 2020 revision, which referred to the state court at the seat of the arbitral tribunal. This limitation does no longer exist in Switzerland. By the way, it doesn't exist in England or Germany or the US either. You may have read that in the US, the situation is not so easy. The matter is now going to the Supreme Court on the basis of a certiorari writ because there has not been any consistent practice by the federal or state courts in the US on that matter with regard to the famous paragraph 7889 of the US Code. The new Article 185A addresses both interim and evidentiary matters. As you can see, Article 185A1 deals with interim or conservative measures, and Article 185A, paragraph 2, deals with evidentiary matters. This is a rather fundamental change, and it means that the foreign arbitral tribunal or one of the parties seeking assistance in such matters from a Swiss state court does no longer have to use the channels of international judicial assistance. And whoever has gone through such proceedings knows exactly what I'm talking about. Now, a direct request to a Swiss court will have the effect to simplify the arbitral procedure and make it more user-friendly in both respects, both interim measures and evidentiary measures. An important addition in this context is a new paragraph 3 of Article 184 that you can see here, according to which the state court may apply or consider other forms of procedure. And that means it is possible here to take evidence by a Swiss state court, for example, on the basis of cross-examination, or maybe, and that's a disputed matter, even using written witness statements. That's certainly a very good addition to our law, because we're dealing here with foreign arbitral tribunals. That is also common law type arbitration that is used to cross-examination and written witness statements. But it remains to be seen whether the Swiss courts will be willing to apply these methods and to what extent. Back to you, Philipp.
Thank you, Daniel. And ladies and gentlemen, I'm moving to an entirely different topic. We are now moving to the proceedings before the Swiss Federal Supreme Court in connection either with an application to set aside the award or an application for revision or revocation of an award. Now, the provision I'll be discussing with you is not to be found in Chapter 12 of the Swiss Private International Law Act, but it's to be found in Article 77 of the Swiss Supreme Court Act, and the new provision is the paragraph 2 B's, which states that written submissions may be made in English. Daniel has already alluded to that novelty in his introductory remarks. And indeed, that was one of the most hotly debated, or maybe the only hotly debated provision during the parliamentary discussions. So what's the scope of that provision? It's clearly limited only to written submissions made by a party, either the party requesting the setting aside or the revocation of the award, or the party defending itself against such application. All communications by the Supreme Court itself will remain to be in one of the official languages of Switzerland, and the same holds true, of course, for the judgments the Supreme Court will ultimately render. The same holds true for the rare public deliberations the Supreme Court may hold in connections with these type of proceedings. What will remain, and that has always been a generous attitude of the Swiss Supreme Court, the Supreme Court usually does not require that any exhibits filed in the arbitration, including any submissions filed in the arbitrations, have to be translated into English. So on top of that, we have now these new amendments, which definitely will help the parties save translation costs, which will facilitate communication between counsel seized with the representation of a party in the setting aside or revision proceedings. And also will, of course, make it easier to comply with the comparatively tough deadline of 30 days to file an annulment action against the award. So definitely a novelty which I'm sure will be welcomed by many foreign users in particular. With that, I hand back to Alexandra to moderate the Q&A part of the session.
Many thanks, Philipp and Daniel, for your presentations. Very interesting. So we have a few questions that came in during your presentations, and I suggest we turn to them already. A first one that will be addressed to you, Philipp, which is in relation to Article 178, paragraph A, with respect to the unilateral arbitration clauses. It's from John Girsberger. And the question is, are minority rights and shareholders also subject to the imposition of such arbitration clause in the articles of a company? And I'd also like to add another sort of related questions in the context of unilateral arbitration disputes in the context of corporations, which is our unilateral disputes, unilateral arbitration clauses, the statutes of a company also applicable in shareholder disputes. So it's two questions for you there. Thank you.
Thank you. Turn to the question of John first. John, it first, of course, depends on where the company is incorporated. Speaking of a Swiss corporation, yes, the minority rights and the shareholder are also subject to the imposition of such an arbitration clause in the articles of a Swiss corporation, but as stated, there's a qualified quorum required pursuant to Swiss company law in order to introduce that type of a provision in the articles of incorporation at a later point in time. I would submit that when it comes to a company incorporated outside of Switzerland, but providing for arbitration in Switzerland in its articles of incorporation, it's a matter of the lex corporationis of that company. As I've explained, I think the reference to Article 178.2, limited mutatis mutandis, and I think choice of law or the seat of arbitration cannot play a role. It should be the law governing the corporate dispute, which pursuant to generally accepted conflict of law principles is the law of the country in which the company is incorporated, which should decide whether minority shareholders may be bound by such arbitration clause, even in instances where they have not agreed to their introduction. So I think one really has to look at the law applicable on the merits or the law, the lex incorporationis, in order to assess the matter. Turning to Alexandra's questions, shareholder disputes, to the extent they are based on a shareholders agreement or a joint venture agreement, they are not covered by the arbitration clause in articles of incorporation of a company, at least not from a Swiss law perspective, because between the shareholders themselves, there is no corporate relationship in the Swiss law understanding, save, of course, for instance, if a director is a shareholder, which for a long time used to be a requirement, but is not necessarily a requirement anymore. But then for the direct relationship between the shareholder in his capacity as a director and another shareholder, then the arbitration clause in articles of incorporation may apply. But if it's only the quality as a shareholder only, at least in the Swiss corporate law context, these types of disputes would not be covered by the arbitration clause in the articles of incorporation.
Thank you, Philipp. Let's turn to a question, I believe, from Mr. Adam Samuel with respect to Article 178, Paragraph 1. That will be addressed by you, Daniel. The question is quite straightforward, which is an oral agreement to a written document sufficient?
The answer is no. That was exactly the point which was disputed during the consultation procedure. That was the intention of the drafters, meaning the Federal Council, that this should be allowed, and one decided against it just because of the evidentiary problem there, because that's rather a matter of consent than a matter of form. Now, I cannot predict what the Federal Supreme Court will say, but there are indications that there needs to be a objective documentation of an exchange of writings, something that's also required by the New York Convention. So if you have an email correspondence where both parties exchange, for example, a contract containing an arbitration clause, and they do not dispute that part of the contract, that would suffice. There is even a case by the Swiss Supreme Court of about 5 years ago where this was discussed. The question was ultimately left open for another reason, but there was about an obiter dictum by the Supreme Court, which could be interpreted to say there is an exchange needed. But in this very case, while the contract was not signed at the end, there was an exchange of drafts, and the dispute resolution clause, the arbitration clause, was not disputed by either party, and that would suffice as an exchange of writings according to Article 178.1 of already the existing, but certainly the new law.
Thank you very much, Daniel, for this clear answer. Let's now turn to a question that came in from Professor Bonomi with respect to Article 176, which has been covered by you as well, Daniel. So the question is in reality two questions. First of all, because of the change in Article 176, the internationality will have to be determined with respect to the party agreement and to the arbitration agreement, and not to the party to the proceedings, as you've explained earlier on. And so the question is whether this also applies to the non-signatories.
First question, I have to make a confession. In paragraph 1, we should have highlighted also the middle line where it was specified what I talked about, namely that the time when the arbitration agreement was entered into is decisive. So that should be also in correction mode. I'm sorry for that. The second is really the question by Andrea. Hello to you. Nice to see you at least in that way again. The new law does not say anything with respect to the extension of arbitration agreements to third parties. And that's a conscious decision, because it's a difficult issue that would have required, I think, a very detailed rule, which would nevertheless not be sufficient to address most cases that we have encountered and we have seen in not only the Swiss Supreme Court case law, but also in abroad. I mean that there's such a variety, and depending on the circumstances, on whether an arbitration agreement is deemed to be extended to non-signatory parties, that this was not wanted by the Swiss legislator, who really wanted it to be a lean legislation, or to continue to be a lean legislation. So that issue is not at all covered by Article 176. And it does not give you an answer on what is meant by third parties that should be included in the arbitration.
Thank you, Daniel. In the interest of time, I suggest that the second question of Professor Bonomi be reserved for later if we do have more time, and that we switch to a question that came in from Martin Bernet. For you, Philipp, with respect to the new provision, Article 77 2 bis, on the possibility to file English submissions before the federal court. So the question is, do you expect this possibility to be used frequently in practice? And would a prudent party not prefer using a Swiss official language to be sure that the federal court grasps all these points? And I would add, are there any sort of advice or tips that you would provide to our foreign colleagues that are listening to us in case they want to file, or even Swiss petitioners for that matter, but more so foreign petitioners in case they want to file English submissions directly before the Swiss Federal Supreme Court?
I think that is absolutely to the point. I think that what has to be balanced against each other by counsel representing a party before the Swiss Federal Supreme Court is prudence versus cost savings and efficiency. If you want to go the prudent way, I would recommend to rather use an official language, because what in particular our foreign colleagues need to know is that our Supreme Court is quite formalistic. and the Article 77 actually puts a higher formal threshold for annulment actions against arbitral award than you might have in other proceedings before the Swiss Supreme Court. So you have to very specifically identify the violations or the grounds for annulment in your submission, and there is a certain risk, of course, that that precision gets lost if you're using the English language and not one of the languages which otherwise is used in the context of Swiss procedural law, and one of the languages with which the Supreme Court is, of course, more familiar. So I think if you really want to go the prudent way, yeah, it's probably to be recommended to use one of the official languages.
Thank you very much, Philipp. Now let's perhaps turn to another question from Sir Adam Samuel. I believe it's in relation to Article 180, letter A, paragraph 1. The question is with respect to the challenge of arbitrators, and the concern or question is whether do you see a risk that it be used to reopen cases abusively by suggesting that new evidence of a decisive nature has emerged?
Sorry, I missed 198 revocation. Yeah, I'd be fairly relaxed about that because our Supreme Court is extremely strict in that respect. I mean, we have the same or similar provision when it comes to revision of judgment by state courts, including judgments of the Supreme Court itself. And the Supreme Court threshold for the exercise of due diligence in that context is very, very high. And parties are rarely successful in making the point that they could not have discovered that evidence even in the exercise of due diligence. So parties can give it a try, but I think with very little likelihood of success. And of course, what one has to bear in mind under Swiss law, awards are final, even if you initiate an action for revocation or an annulment action before the Supreme Court, there will be no automatic stay of the enforceability of the award. So I think the risk of dilatory tactics by parties are minimal in light of the strict test the Supreme Court is applying.
Thank you very much, Philipp. And perhaps just to come back to one innovation of the new law, which is the possibility to seize a state court judge in case the arbitration agreement does not provide for a designated place of the arbitration, that it says either arbitration in Switzerland or doesn't even say anything at all. And yes, I make you go back to the beginning of the statute, because it's like in Article 179, paragraph 2, where you find this new possibility. And so, as we can see now, this not only applies to the possibility of seizing a state court when the arbitration clause only refers to arbitration in Switzerland, but also when there's no specification at all, when there's a sort of a clause blanche, as we call them. And my question is, in these last case of a clause blanche with no designation of a place, do you believe that we still need to have an underlying requirement of a connection with Switzerland in order to be able to seize the Swiss court, or not?
I don't know whether you address it to me. I take the liberty to start because we had a discussion on this issue just before the webinar started, Philipp and myself and you. And I think we finally agreed on the rule that a Swiss court can, in general, then assume jurisdiction to determine the seat, even if the seat is not obviously meant to be in Switzerland. That is close to what we have now in France, and we've seen that France assumes jurisdiction almost in any case in this regard. We have discussed this within the expert group that advised the Federal Council in the years 2016 to 18, and I think the common denominator was that we should be careful but not overly strict, because we should think about the protection of the parties seeking arbitration. They should not be thrown around by courts of various countries. So why not take it upon a Swiss court? But depending on the circumstances, that could be different if the case shows, or the facts show, that the parties have not really thought about Switzerland to be relevant in their dealings, but that's a case-by-case thing. And if I have the word already, I would like to answer the second question of Andrea Bonomi as well, who said that the form requirements that are now valid for all kinds of important party declarations, namely the opting out or the waiver of 192, which is a almost unique provision in Swiss law, and it's very much criticized. Other laws have it too, Belgium and Sweden, but it's very much criticized. That this waiver now is also subject to this new form requirement, and Andrea has rightfully pointed to the rich case law of the Supreme Court, which asked for an express waiver when it came to Article 192. And Andrea asks whether this case law is now moot because of the new form requirement. I would say clearly no. It's a double requirement now. You have to use the form, so a text, according to Article 178(1), but it should also be clear that this text means a waiver of the challenge and the revision or the revision proceedings before the Swiss Supreme Court. So I don't think that the case law has become moot. It has added now a form requirement, but the question whether it's a clear waiver remains subject to the circumstances.
Thank you very much, Daniel. I'm mindful of the time. I think we've slowly reached or even exceeded our time. Unless there's anything, Philipp, you'd like to add, or Daniel, you'd like to have. There's a lot of questions that are still coming, but do feel free to reach out to the speakers to ask them this question by way of email after this webinar. They will be very happy to continue the discussion. Unfortunately, since we have a limited time, I have to draw this webinar to a close not without thanking our speakers for their insightful presentations and for all of you participating in today's webinar. It's been a challenging task for our speakers to cover such material over a limited time, and they've done an excellent job, and I hope they have managed to give you a glimpse of the new amendments of the law and reassurance that Chapter 12 will remain this concise and modern and user-friendly law that it has been so far, and only an even better and more user-friendly version. So thank you very much all for your participation today. Again, you will find these slides in the file folder and on the ASA and SCAI websites. And just a word to remind you that the next ASA SCAI webinar will be held on 21st of January 2021, as Alex mentioned at the beginning, on the topic of the appointment of arbitrators and mediators. So mark that in your agenda. For now, it's time to say goodbye and have a safe and happy holiday season. Thank you very much. And thank you again, Daniel and Philipp.
Thank you. Bye, everybody, and happy holidays.
Bye.